politically.
Yeah, thank you, Andrew, and thank you for the invitation. And before I begin, I just, if I may, just also extend my appreciation and thanks to Anne Hertzberg, who joins us too, who I've been working very, very closely with on this issue, and the remarks which I'm about to make are very much, I would say, are the product of our work together as a team effort. But Andrew, the apartheid allegation against Israel has had a significant year in many respects, because at the start of the year, we had the publication of reports by B'Tselem in January, and then Human Rights Watch, alleging, as B'Tselem put it, a regime of Jewish supremacy from the river to the sea, evoking maximalist rhetoric, contending not just a regime of institutional discrimination, or not just the existence of institutional discrimination, which, by the way, exists in many states throughout the world as objectionable and as abhorrent as it is. A finding of institutional discrimination would not be unique or alien to the United Kingdom, for example, where the Macpherson report found findings of institutional discrimination in the Metropolitan Police. It's a problem which all mature democracies have to contend with, and which mature democracies do contend with. So that's not the focus so much. What we're talking about today is the allegation of apartheid, which, as a crime against humanity under the Rome Statute and under the Apartheid Convention itself, and as a war crime under the first additional protocol of 1977 to the Geneva Conventions, is of a fundamentally different nature, in my view, to the prohibition, which is a peremptory norm of international law, of systematic discrimination. But Andrew, the allegation is not new. In fact, it's been circulating for 7 decades with fluctuating degrees of intensity. And nor are the actors who are involved in the discourse of apartheid or contending the existence of apartheid in Israel new adherents to it. Some of them, notably Richard Falk and John Dugard, have been engaged for more than 40 years in this project. And as Daniel intimated, this is a project that is intimately connected with the delegitimization of Israel as a Jewish state. In fact, Andrew, Human Rights Watch's report this year closely tracks a 2009 report that was authored by the Human Sciences Research Council of South Africa. And that report was authored by many of the same authors and organizations active today in promoting the apartheid allegation against Israel. So this is an allegation which has been repackaged as a threshold crossed, which has been branded as a new phenomenon, but which in fact reflects a long campaign which Daniel spoke to in the macro context, and I'm going to drill a little bit deeper into with respect to the claim of apartheid itself. The claim of connecting Israel with South African apartheid originates in Arab and Soviet propaganda from the 1950s and 60s, which argued that the Torah's conception of Jews as a chosen people legitimized the seizure of other people's territories, even as it claimed, and I'm quoting, that the Jew is a superior race and the others are inferior. Judaism itself was condemned as prescribing racial exclusivism and justifying crimes against the Gentiles, Andrew. And this is, as I say, Arab and Soviet propaganda from the 50s and 60s. That discourse, in turn, was adopted by PLO, Palestinian Liberation Organization, intellectuals. A 1965 article by a man named Fayez Sayegh, which just this year, Andrew, was relied upon by Noura Erakat on the European Journal of International Law's blog by Tarek Bakoni in the New York Review of Books, and most recently by former employees of Al-Haq, Rania Mahareb and Piers Clancy, in a recently published article, exemplified this trend. And I'm just going to drill down a little bit into some of the contentions made by SAIEG, which have been relied on this year in framing this discourse of apartheid. SAIEG referred to Israel as, and I'm quoting, an alien body in the Middle East, and he alleged that the supposed common ancestry of Jews masks a fake and constructed nationhood, whilst claiming at the same time, and here's the nexus with apartheid, that not even in South Africa or Rhodesia has European race supremacism expressed itself in so passionate a zeal. And he highlighted Zionism's congenial, essential racism and aspiration to racial self-segregation. Noura Erakat, who I referred to on the European Journal of International Law's blog, quotes SAIEG to conclude that, and I'm quoting, "The Zionist belief that Jews constitute a race and a singular people, irrespective of religious piety or identification, produces three corollaries: racial self-segregation, racial exclusiveness, and racial supremacy." So, Andrew, the connection I would suggest between these contentions and Jewish peoplehood, Jewish nationality, and Jewish identity are very, very clear. Following the Six-Day War, the apartheid rhetoric accelerated, but the focus remained on Israel's character as a whole, not simply conditions in the West Bank and Gaza, resulting from military government there, but in relation to Israel as a whole, from the river to the sea, as it might be put. Sometimes Zionism itself was characterized as apartheid, sometimes as a form of racism alongside apartheid. Daniel mentioned the culmination of this effort was General Assembly Resolution 3379, which condemned Zionism as racism. Notably, Fayez Sayegh was a co-author of that resolution. Although it was repealed in 1991, the theme persisted and was revived, as Daniel also mentioned, at the 2001 World Conference Against Racism in Durban, where Israel's, quote, brand of apartheid was deemed a crime against humanity. Moving into the 90s, an article in the Journal of Palestine Studies advocated moving from an occupation paradigm to apartheid as a means to weaken US support for Israel, whilst explicitly rejecting conditions solely in the West Bank and Gaza. But the 90s represented somewhat of a hiatus in this story. Again, as Daniel spoke to, because of the developments in Oslo and the peace process in that decade. But by 2007, John Dugard, who I mentioned previously, had been appointed UN Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967. And he queried the legal consequences of a regime of prolonged occupation with features of colonialism and apartheid, recommending that it be addressed in an advisory opinion of the International Court of Justice. I mentioned in 2009 the work of the Human Sciences Research Council of South Africa. In 2000, they took up Dugard's question and published their preliminary study, and that's titled Occupation, Colonialism and Apartheid. Andrew, there's nothing in 2021's human rights reporting that is not contained in the May 2009 study by the Human Sciences Research Council. This is not a new story. And that report was authored by names that may be familiar, including Virginia Tilley as its editor, Victor Catan, Michael Kearney, John Reynolds, and Ian Scobie. John Dugard and Michael Svard, among others, provided contributions, and as I say, laid the foundation for much of the reporting alleging apartheid in the years to come. But fast forward briefly to 2017, when Richard Falk co-authored a report published by the UN Economic and Social Commission for Western Asia. That relied extensively on the findings of the 2009 report. One of Falk's co-authors, Virginia Tilley, was also the main editor of the HSRC report. The authors concluded that Israel is guilty of the crime of apartheid, but the UN Secretary General directed that the report be formally withdrawn within days of its publication. And the reasons for that relate may relate to delegitimization of Israel's identity of a Jewish state, which was part and parcel of that report. Andrew, to summarize, this history demonstrates that the threshold that's been crossed this year is a threshold which has been crossed by human rights organizations rather than Israel itself. And it also demonstrates that rather than offering a workable solution to the problem of prolonged military government in the West Bank and Gaza, human rights organizations have instead adopted a discriminatory discourse of the Cold War and a reversion to the rejectionist framework, shrinking the space for recognition, negotiation, peace with Israel, more evoking the spirit of the Khartoum conference rather than the Oslo conference. And over to you again, Andrew, if you've got any more questions.
No, thanks, Josh. That's been very helpful just to sketch the context. So basically, what you're saying is, I mean, it's more or less a political campaign driven by certain ideological frameworks to delegitimize the Jewish state. But drilling into the legal issues, I mean, is there a case to be made? Do they have a case that under the definition of apartheid, because there is a difference between the way being a Jewish state, the way Jews are treated in Israel, and I suppose we have to make a very clear distinction between Israel itself and the disputed territories where different regime applies. Is there a case to be made, or I mean, could this, for example, lead to a case in the International Criminal Court?
Andrew, I think that an important way to approach this question is first to pick up the question of the definition of apartheid itself, which you referred to, and perhaps the first point to note is that there is no singular definition of apartheid under international law. And the reason for that is under international law, apartheid exists in two or perhaps more accurately three forms, which I've already alluded to. The first is that at the interstate level, under international law, irrespective of any treaty relationships, it's right to say that a norm has crystallized that has widespread state support, including the support of Israel as a signatory to the International Convention for the Elimination of All Forms of Racial Discrimination, which prohibits the practice of apartheid by states and as between states. The International Covenant is nearly universally ratified, and it contains, as I say, a prohibition of apartheid as between states in its Article 3, but it doesn't offer any definition of apartheid as such, so it doesn't take your question any further. So what is the definition of apartheid? Well, then we look at the other forms of apartheid, which I described, and those are apartheid as a crime, as an international crime. And the first type of crime is apartheid as a crime against humanity. And the second type of crime is apartheid as a war crime. Now, apartheid exists as a war crime, as I mentioned, in the first protocol to the Geneva Conventions of 1949, the protocol, additional protocol 1 of 1977. But additional protocol 1, although it criminalizes apartheid as a grave breach of that additional protocol, it doesn't offer any definition of the crime. The treaties which criminalize apartheid as a crime against humanity have not gathered the same level of widespread support as the International Covenant for the Elimination of All Forms of Racial Discrimination. Those treaties are the Apartheid Convention of 1973, which has been ratified by 109 states only, and 1998's Rome Statute, which established the ICC, ratified by 126 states, or acceded to by 126 states, which both define apartheid, but don't have that level of universal support, you may think, to establish those crimes against humanity as crimes against humanity under general international law. Israel, for its part, has ratified none of those treaties. And there's a very real question whether it's the crime against humanity of apartheid under them is binding on individuals under international law at all, when or if it's committed by nationals of states which have not ratified those treaties, or in the territory of states which have not ratified those treaties, pursuant to which it's criminalized. Another consequence is that there is no singular definition of the crime under international law. The definitions of the crime, there are definitions of the crime contained in both the Apartheid Convention and in the Rome Statute. But when we talk about the definition of apartheid, or when you talk about the definition of apartheid, we're really talking about the definition of crimes under treaties, which many states, including Israel, have never consented to be bound by at all. And that goes squarely to the remarks you made at the opening about the very basis of international law being the consent of sovereign equal states. But Andrew, that's, as you know, that's not the end of the story. Not least because, as you alluded to in your question, in February of this year, a majority of the pre-trial Chamber 1 of the International Criminal Court ruled that the ICC is permitted to exercise its jurisdiction, including over the crime of apartheid as it's defined under the Rome Statute, over what's construed as the territory of the State of Palestine, which it defined by majority, 2 out of 3 judges, as comprising the West Bank, Gaza, and East Jerusalem. Now, Andrew, time doesn't permit me, nor does the scope of my brief today, to go into the merits and demerits of that decision, but it is relevant for our purposes because it operates to provide the basis for the contention that it's the Rome Statute's definition of apartheid, which is binding on individuals, including Israelis in the West Bank, Gaza, and East Jerusalem, even if, which can be assured, that purported basis is wholly disputed and rejected by Israel. So, Andrew, if I may, in the time I have remaining, just briefly focus on some of the elements of the definition of apartheid as a crime against humanity under the Rome Statute. But if you've got any questions on what's just been said up to this point.
No, go ahead, Josh. We've got a couple of minutes left, so I think this is really important. Yes.
All right. I'm only going to touch upon the element of domination as an element of the crime of apartheid. Anne and I are publishing a full report on all of the legal elements and the historic narrative of the development of the apartheid allegation against Israel on the 9th of December. So I would hope that if anyone's interested in what we have to say today, you'll be able to read more fully developed material on each of the elements of the crime on that date. But I'm just going to focus on the element of domination. The crime of apartheid is defined under the Rome Statute as inhumane acts of a character similar to those referred to in paragraph 1, committed, and that's other enumerated crimes against humanity of murder, extermination, enslavement, deportation or forcible transfer, torture, rape, sexual slavery, committed in the context of an institutionalized regime of systematic oppression and domination by one racial group over another, or over any other racial group or groups, and committed with the intention of maintaining that regime. Now, what is a regime of domination in this context, Andrew? Human Rights Watch provide an answer in their report, and they argue that the element of domination, although it lacks quite a clear definition, appears in context to refer to the intent by one group to maintain a heightened degree of control over another, which can involve control over key levers of political power, land, and resources. And that's quite an interesting suggestion, because what that would imply is that a situation of occupation, which is defined by the existence of effective control under the definition proffered by the International Court of Justice, or overall control in the definition proffered by chambers of the International Criminal Court, would also in turn meet the requirements of the definition of domination as an element of the crime against humanity of apartheid. And one may wonder whether there's a reason for that definition being suggested by Human Rights Watch in this specific context. Curiously, however, John Dugard and John Reynolds, when writing in 2013, argued that the essence of the definition of apartheid is the systematic, institutionalized, and oppressive character of the discrimination involved and the purpose of the domination that is entailed. And their emphasis on the purpose of domination suggests that any legal assessment of that element extends beyond the mere question of factual control and encompasses apartheid's essence as an aggravated form of racial discrimination. In other words, for Dugard and Reynolds, if not Human Rights Watch, the exercise of control must relate to the intent to maintain some kind of racial superiority. And that apparent disagreement, Andrew, between Human Rights Watch on the one hand and Dugard and Reynolds on the other, with respect to this single element of domination, but which may be reflected throughout other elements of the crime too, you may think reflects the muddled thinking which underpins much of the legal analysis of the crime when it's applied to the Israeli-Palestinian situation. And you may ask yourself why that confused thinking may arise. In our work, Anne and I argue that this apparent confusion can in fact be resolved in a more precise way. That's because the Apartheid Convention makes clear that apartheid shall include similar policies and practices of racial segregation and discrimination as practiced in Southern Africa. And we argue that it follows that there's a legal basis to consider the policies and practices of South Africa when seeking to determine the elements of the crime of apartheid. So in this context, such a comparison informs our understanding of domination as an element of the crime. And we argue that the concept of domination can be understood through Southern African practices, therefore, of racial supremacy or baskat in Afrikaans and segregation. Andrew, Trevor Huddleston was an Anglican minister and an early critic of apartheid in South Africa. And he wrote in 1955, "It's not apartheid which has provided the nationalist government with its immense and growing dominance over all the European groups and parties in this country. It is not the thirst for such a negative state of affairs as separation in itself that has so stirred enthusiasm and multiplied votes. It is something much deeper and much more appealing. In a word, it is white supremacy now and always. It's not white self-preservation that is considered a sufficient motive force today. It is white supremacy, that and nothing less." So we argue that the concept of domination as supremacy is central to the conception of apartheid as practiced in Southern Africa. And we argue that it informs the definition of domination as an element of the crime under the Rome Statute. But Andrew, applying that element to Israel, you might think that the existence of a Jewish state does not reflect a regime of Jewish supremacy. And to disparage the concept of a Jewish state by claiming that it contradicts the principle of equality itself denies the principle of two states for two peoples. Well, one of those peoples defines itself and therefore is Arab and Palestinian. The other defines itself and therefore is Jewish and Israeli. And in the West Bank, separate systems of law were prescribed by the Oslo agreements, and those were witnessed by and guaranteed by representatives of the international community. Andrew, those legal arrangements are intended to safeguard and protect the rights of both Palestinians and Jews in the West Bank, not to enshrine regimes of racial supremacy. And notwithstanding real concerns, as I said, regarding the existence of institutional discrimination favoring Israelis in Area C, these concerns, we argue, do not reflect an institutionalized regime of racial supremacy. The discrimination practiced against Jews and Israelis in Area A is arguably a different matter. So, Andrew, we conclude that the NGO reporting this year has broadened the elements of the crime, seemingly in a teleological way, in a manner that's inconsistent with both the principle of legality under international human rights law and the presumption of that crimes and the definition of crimes should be strictly construed as a matter of international criminal law. And for now, I'll leave you to draw your own conclusions as to why this might be. But but look forward to the discussion unless you have any more specific questions for me now.
Josh, thank you. That's been extremely